And that's testimony by Dr. Fowler. Let's bring in our guest to discuss. Joining me now, National Trial Attorney Michael Jaafar. Michael, always great to have you on. Thank you for joining me. If you're the state, what do you do with a witness like this that honestly, at the end of the day, maybe it didn't move the ball forward a lot, but it's necessary to lay the foundation about the fact they tested Karen Read for alcohol and there was presence of alcohol?
I think this witness is important. This is not the witness that's going to really tie in the whole entire forensic and pathology for them with this case. But I think this witness is important. Sometimes it seemed to me like they were fishing, but that's okay because in a state like Massachusetts where you cannot like depose a witness before a trial, sometimes you're not going to know the answer to every single question for every single witness in every single trial. Sometimes you're going to fish a little bit. So I think that the witness was important. It was their witness, right? So they could not ask him leading questions. They had to ask direct questions. But I think that this is the beginning. If they end well with their next expert, I think that when they close this case and they argue the case to the jury, ultimately probably in a couple of months, they can bring in his testimony and give it context, which right now doesn't currently have the context that they want.
Right, I agree, and bringing it context means the jury will then understand what all of this means. So let's go back in because that next witness is on the stand. Nicholas Roberts, a forensic toxicologist, direct examination by the Commonwealth. Oh, I'm glad you're with me, Michael Jaafar, because yes, we got to hear from the defendant in his own words. However, he is not going to testify. Are you surprised or not?
I'm very surprised. Anytime that your child dies at your hands and it's on videotape, I don't see the logic behind not testifying. But also what I'm noticing, Judge Ashley, is this case screams lesser included charges. In New Jersey, near the end of a trial, the judge can allow the prosecutors and the defendants to do something called a charging conference where they would agree on lesser included charges, right? Maybe that's why the attorney told them not to testify. I don't know. But this case screams lesser included charges. This man deserves to go to jail. Look at what he did to his kid. I mean, it's clearly this man deserves to be in prison, right? And he's going to be in prison in his mind for the rest of his life anyway. But is this, murder one? I don't see it's murder one. It's murder, but I don't know about murder one. This case screams lesser included charges. I don't know if that has happened yet, and if not, I would be puzzled as to why.
Well, let me push back on that because the last witness we heard from was Dr. Bodden, and he testified that the cause of death was natural causes from the CPR, and then he specifically said that the bruises on the child were not related to the death. Is that enough for reasonable doubt for this jury to say he didn't kill his son?
I don't think this is murder one. I don't think this is murder one. I don't believe that this is murder one. I believe that there's some form of negligence, some manslaughter here that happened, in my opinion, based on the fact that he put a kid. I mean, even the treadmill tells you a blatant sign, this is not for minors, right? And so I definitely do not believe that this is murder one. I believe there's ample reasonable doubt that this is murder one. That's why I think lesser included charges, might be justified here, but yeah, definitely not murder one.
And I think they might be justified, but I don't know. I think the right juror could hang on to Dr. Bodden and say, no matter what he did to the child that was abusive, he did not kill his child. We'll have to wait and see. All right, stay with us, Michael. We need to take a break. Of course, when we come back, we will go back to Massachusetts and Karen Read to bring you more of that testimony to hear exactly what the alcohol level in the blood means. Was Karen Read drunk or not? Stay tuned. Now, National Trial Attorney Michael Jaafar still with me. I was about to jump into the question because earlier you said, Michael, in talking about some of this testimony, they're really going to have to highlight it during closing. And I think he just said that portion that the state is going to want to highlight, and that was the blood alcohol content level in Karen Read when they tested her, and the greatest is 0.038. What does that say to you?
I think it says that she's going to be jury goes in there believing that she's at a 0.038, then I mean she was very drunk at the time. What viewers are watching right now is a mini drunk driving defense trial. They're not seeing it. This is not anything different. To those of us who've done DUI cases, we know this is exactly the playbook of the prosecution and the defense. The prosecution is doing what they have to do. The defense are going to have to get up here and say, well, doesn't that vary wildly? Is it that, you know, she's a thin person, she's small? Couldn't it? And this was taken long after the fact, right? But I think Judge Ashley, this cuts against her because everybody knows that this is not a PBT, a portable breathalyzer test that the police takes from you when they arrest you to give probable cause to arrest you. This is the blood test. This is the gold standard for gauging someone's drunkenness. And they took this hours, I think a day after the incident, and she was still basically drunk. I've had clients who've had this amount of blood in their system when they were arrested, and they blacked out and they literally ran into walls. And they only knew they ran into walls because I read it to them off the police report. Hey, you ran into a wall and you were passed out. It would tend to show that she did run him over. That's the direction of these types of results.
Well, okay, the direction. First of all, I want to highlight that when I said the 0.038, that's the high level. There was also a low level.
Yeah.
So, of course, the defense is going to say, well, the low level could be reduced by some of those factors you mentioned. But, Michael, okay, arguably, she's drunk. She's really drunk. When they leave the bar and she goes and drops him off, but I don't think you can then conclude, clearly she ran him over because she was drunk.
Yeah.
How is the state going to make that piece stick?
It's not going to be very easy, right? Because at the end of the day, if she was that drunk where she ran him over, presumably she would have then ran into a tree, right? I've seen this before where people run other people over, but they don't end in their driveway, you know, 7 miles away, right? So the way the state is going to do it is the state is going to have to basically tie in multiple layers of evidence and say, look, you want the jury to believe that all of these these highly decorated police officers all conspired together, and you were drunk by total coincidence. And the adopted children of the victim who said that you guys were fighting, he tried to kick you out of the house. You want us to all believe everybody just concocted this whole entire thing together. So I think this is not like a smoking gun for the prosecution, but it's helpful for the prosecution. That's my opinion.
Yeah, I agree completely. It's really helpful for the prosecution. Stay tuned. We'll get you back inside that courtroom.